Good afternoon. Thank you for joining us today. We are talking about loss of wage earning capacity awards and settlements in New York workers' compensation cases. So thanks for joining us today. I hope your summer is going amazing. I hope you're enjoying the extremely hot and gross weather we've been enjoying here. Welcome. We are here to talk about New York workers' compensation claims. And if you're here in the summertime, I know you must be interested in this topic. So bless you for your interest. But if you're here, please take advantage of the fact that you're here. This is always presented 100% live. And so take advantage of that. Ask me questions. There's a question box in this webinar program that you can type questions into me live. And when I reach the conclusion of my prepared remarks, my goal is to answer as many of your questions as I can. So please bring them to me. I really enjoy that aspect of it. And if you are participating live, I should say, take advantage of this opportunity to ask me questions. It could be about anything. It doesn't have to be confined to simply this topic of loss of wage earning capacity awards and settlements in New York workers' compensation cases. It could be any topic. Please don't tell me the name of your case or any particulars. Give it to me generally, and I will respond. I will say your name, your first name only, so you know I'm responding to your question. I will then read your question for the entire audience, and then I will do my best to respond as best of my ability allows. So please take advantage of the fact that you are here live on this beautiful summer day, spending time with me to talk about workers' comp. Bring your questions. All right, let's dive into today's presentation. I do have some prepared remarks to work through. Again, this is for instructional purposes only, and please do not consider a webinar or anything you read on the internet or any video you watch on the internet as legal advice as to any particular matter. Today I'm going to talk about a subject we've talked about many times, which is what is maximum medical improvement, how do claimants avoid maximum medical improvement, and then I'm going to dive into the meat and potatoes of today's discussion. What is a loss of wage earning capacity award? How do we avoid it? How do we minimize it? And then, of course, how do we position these cases for a Section 32 settlement, which is a lump sum dismissal? And really, that's what you want to resolve your cases at. If the claimant no longer works for you, trying to resolve your case in a full and final lump sum dismissal, goodbye, your journey with us has come to an end, is really the best way to close your case. So that's what we're going to try to show you how to do. All right, what is maximum medical improvement? Well, sometimes you'll see it in medical records or doctor's reports. It's where the claimant has really reached a medical plateau, and we're not expecting that their condition is going to be amenable to any more curative care. Now, that doesn't mean they might still need palliative care, right? Palliative care is just treatment that relieves pain, but doesn't actually alleviate or cure the symptom or the cause, right? It's really just symptomatic treatment. So it's possible for a claimant to receive palliative care, but have reached maximum medical improvement from a curative standpoint. Now, there are some statements, particularly in the scheduled loss of use guidelines, that say that maximum medical improvement cannot be reached prior to 6 months from the date of injury or disablement. However, if the parties stipulate or agree by way of settlement, you can shorten that time period. And generally, the medical treatment guidelines say that maximum medical improvement should be reached within 2 years of the injury. Ha, 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 ha. That's a rare thing. Remember, in this jurisdiction, the claimants can choose and select their own treating physicians. And are they choosing the best treating physicians? Absolutely not. They're choosing the treating physicians that their attorneys are sending them to, who are going to keep them out of work for the longest possible amount of time, so that rarely will you see the treating physician voluntarily say the claimant has reached maximum medical improvement. And even when we think that treatment has come to a medical plateau, they will then claim that A, they need some kind of new surgery, or there's a potential hypothetical treatment out there that they would benefit from, or B, they like to bring in new body parts and try to start over the case. So be on guard, be wary of those traps. The board promulgates a form C-4.3, in which the petitioner's treating physician and the expert physician is supposed to utilize to determine that the petitioner has reached maximum medical improvement. Now, if their physician, the treating physician, is estimating permanent disability, they are conceding that the petitioner or the claimant has reached maximum medical improvement. So keep that in mind. All right, so the first step is really finding that the claimant reaches maximum medical improvement. And unfortunately, in this jurisdiction, that is often a fight and a challenge to determine has the claimant reached maximum medical improvement. Remember, they're going to do everything possible they can to stretch this case out. They are going to do everything they possibly can to try to bring in new body parts. And even when you go before the judge and you say, Judge, look, we've got 3 physicians that say they're fine, they don't need any more care, they're going to then, of course, assert that there's this potential hypothetical care that maybe they could receive, maybe someday that would make them better, and try to keep their case open. So we have to often litigate this issue of maximum medical improvement. Once we've done that, we can then move into today's topic du jour, which is loss of wage earning capacity, or as it's commonly referred to as LWEC. And this is the way we compensate claimants for injuries involving non-scheduled body parts. So what kind of body parts does that mean? Low back, cervical spine, thoracic spine, and psychiatric, any neurologic impairments, and anything else that doesn't fit in the scheduled loss of use chart. So what is the scheduled loss of use body parts? Hand, finger, feet, toes, arm, leg, eyes, ears. Everything else, and particularly your systemic injuries, your injuries that are involved things like the respiratory system, the nervous system, the psychiatric abilities of the claim, all those things are going to be compensated in terms of loss of wage earning capacity awards. Now, in order to make one of these awards, the judge has to find a couple things. They have to determine a rate at which compensation should be paid, and they have to figure out what the durational cap is that applies. So the first thing they have to do is come up with the rate that is going to be based on their loss of wage earning capacity formula, and then the judge has to make an award. Now, where does this come from? Where does this information come from? Well, there's a capped number of weeks in this jurisdiction for a loss of wage earning capacity award. And remember, loss of wage earning capacity is less than totally disabled. Totally disabled is perm total for the rest of their life. So we're talking about cases where they are 99% or less disabled. And it's a very interesting chart in which a 1% of disability is equal to 225 weeks of compensation. And at the minimum possible rate, which was in effect $150 a week, this is a pretty significant award. So as you go up the chart, you receive more weeks, but of course they are capped for your permanent residual disability in this jurisdiction. Now, compare this to something like the scheduled loss of use chart. You discover that, wow, we are compensating loss of wage earning capacity awards for a much longer duration comparatively to the scheduled loss of use chart. What I mean by that is an injury, complete loss of a finger, you can get 30, 50, or 75 weeks of compensation. But I sprained my back, I have a very minor back sprain strain, you can get significantly higher number of weeks of compensation for that. So just be mindful that these loss of wage earning capacity awards are generally going to have a higher dollar exposure associated with them for what can often be called much more subjective or harder to prove, or I'll just say less objective injuries, claims, or complaints. Also take a note that the durational caps are extremely flat in New York. So if you look at what a 1% disability is there on your chart, it's equal to 225 weeks of compensation. 75% disability is 425 weeks of compensation. And so you can see there's not really a tremendous difference, and there's a very gentle slope to the increase in weeks of compensation that the claimant receives. And this is really interesting to me because if you think about where compensation has been sort of placed in this chart, it's down at the bottom end of the chart. 1%, 2%, 5%, 7%, 8% disabilities, very small amounts of disability are receiving a lot of weeks of compensation. Now, compared to something like New Jersey, here's New Jersey's chart. 1 week of compensation, or 1% of compensation, you get $1,000. You just get 6 weeks of benefits. Versus New York, 1 week of disability, you get 225 weeks of compensation. So if you're familiar with other states and the way that they compensate permanent residual disability, where your amount of money and your award ramps up significantly as your amount of disability increases, you're going to be a little surprised by New York because it's got a relatively flat chart and all of the compensation is crammed down into the bottom of the chart. So obviously when this was negotiated back in 2007 and 2008 in the legislature, the plaintiffs had better advocates there in the legislature than the insurance companies did because they've managed to really stick a lot of compensation and pay people a maximum number of weeks for minimum amount of injury. So the judge has got to determine the amount of loss of wage earning capacity and take into account the following things: the claimant's medical impairment, their functional ability, and vocational factors. So really, when you're thinking about how do you make a determination of loss of wage earning capacity, really think about these steps. First step is, has the claimant reached MMI? If the claimant has reached MMI, then you can move on and start determining how much compensation they're actually going to be due. Both sides will get impairment ratings. What's an impairment rating? Well, we're going to hire an expert, an independent medical evaluator, to come up with an opinion of the the claimant's overall disability. And so is the claimant. They're usually going to go to their own treating physician, which is pretty interesting that they go to their own treating physician who says, yes, I treated this person for 5 years, and look, they're worse than when I started, right? Their disability is really bad. They have a very huge impact on their working ability. But anyway, both sides are going to get these impairment ratings. They're going to exchange them. The judge is supposed to consider the claimant's functional ability. And then the judge is supposed to consider their vocational abilities and come up with an overall determination of the claimant's loss of wage earning capacity. Then that's while this typical litigation moves forward. Now, remember that the claimant has to reach maximum medical improvement. And then the doctors are supposed to apply the New York Disability Duration Guidelines. What is that? Well, New York came up with its own system for doctors to evaluate medical impairment. They did not use established or prior systems. For example, this is not based on the American Medical Association guidelines for estimating disability. This is not taken from the American Academy of Orthopedic Surgeons' ways of estimating orthopedic disability. They just made up their own, okay? And it's called the Disability Duration Guidelines, and they've published it. And they've even come up with their own language involving severity rankings and other criteria for how the doctor is supposed to take something which is quite subjective, for example, someone's subjective feelings of pain or subjective feelings of psychiatric trauma, and turn that into an award or classification of impairment. And they've come up with these very scientific looking rating systems and ranking systems. Here's an example of what the kinds of disability the court should find for a claimant that has a soft tissue spinal condition with no surgery. And I'm cherry picking this as an example to give you an idea of how the system works. So if you look at the example that I'm putting up on the screen right now, soft tissue spinal condition, non-surgically treated, this is taken directly from the Disability Duration Guidelines. As you can see, going down the left-hand side, as you see it on your screen, there's a Class 1, Class 2, and Class 3. So there's a classification. And then there's a severity ranking. You can see the severity ranking goes from none, A, B. And if I included the rest of the chart, it goes all the way up to J for significant disability. So if you look at a Class 1 injury, Class 1 is I have a soft tissue spinal condition. Okay, what would that be? I have a soft tissue muscle sprain strain in my low back. I have no symptoms and no clinical findings. So this is someone who goes to the doctor and says, I got hurt at work. What happened? I bent over to pick up a pencil. My back hurts. It hurt. It did hurt. Does it hurt now? No. What does that mean? They have no symptoms. And the doctor performs an evaluation, or maybe looks at radiographic testing and says, oh, there's no clinical findings. In that case, they would give a severity ranking of none. Okay, so that's a Class 1 severity ranking, none. Let's take a look at Class 2, right? Same injury. I bent over at work to pick up a pencil. When I stood back up, my back hurt. I had some pain in my low back. Now that's the medically documented injury. Now, the claimant has to have all of the following. 1, recurrent or persistent symptoms. That means they have to say, my back still hurts. 2, no objective clinical findings consistent with spinal pathology. In other words, the doctor performs an evaluation and says there's nothing here that's consistent with an actual spinal injury. And 3, nothing on imaging findings. No X-ray, CAT scan, or MRI findings which correlate with the claimant's complaints of pain in their low back. Well, in that circumstance, this would be classified as a Class 2 severity ranking A injury. Again, all we have here are complaints, nothing objective, no findings, period. And that's the problem with, my problem with these disability duration guidelines. And particularly with these subjective or inchoate or vague sort of injuries that we're compensating people for, really the claimant just has to say something happened and I still feel some pain from it in order to have a severity ranking, in this case, A. And I'm going to show you what that translates to in dollars in a minute. Then the doctor's supposed to take the severity ranking and put it through another set of charts to come up with exactly how many points are added. There are supplemental tables, etc. And this is going to result in an overall ranking, in this case, of an 11.1 class 1 type severity ranking B injury, right? That's what this person has, a class 1 severity ranking B. Well, what does that mean, right? Because remember, we're compensating people in terms of dollars and for a duration, which is based on a percentage of disability. But these disability duration guidelines don't give you a percentage of disability. They'll give you statements like severity ranking A, classification 1. How does that translate into percentages? Well, there's a secret key in the back of the disability duration guidelines, and this is on about page 140 of the guidelines. There's this thing called a severity impairment crosswalk. And this is the key to understanding the guidelines, understanding what these rankings mean. As you can see, they have all of the rankings on here, and I copied and pasted this right out of the disability duration guidelines. And it goes from 0 to 6, with 6 being totally disabled. And as you can see, you cannot be, for a low back or cervical spine, totally disabled from any one of these conditions by itself. In our example, we had a lumbar injury that, if you remember, was classification 1 and severity ranking A. Well, that would equate to 1 divided by 6, remember 6 is totally disabled, or a 16.6% disability. And you could simply do the math and determine what the remainder of these weeks' benefits would be worth. Well, we know that 16.6% disability is worth 250 weeks of compensation on the New York Workers' Compensation chart. So that's a very significant finding in terms of the duration or number of weeks, 250 weeks. And again, I'm just taking that from the durational rate cap. Okay, so now what I've told you, and if you're paying attention, is someone could say, I bent over at work, I picked up my pencil, and I felt pain in my low back. Go to the doctor, have no clinical findings. In other words, the doctor performs palpation, makes them do a range of motion testing, maybe straight leg raising tests, all of that's negative. Also does diagnostics, MRIs, CAT scans, any other testing that they do, and that's also negative. But the doctor still has to give them that severity ranking A based on the complaint alone. And that is going to equate to a 16.6% disability, which equates to a minimum of 250 weeks of compensation, okay? I hope you're grossed out, because that's a tremendous compensation for really nothing more than complaints, right? And that is allowed in this jurisdiction. All right, the judge also has to do a review of the claimant's functional ability. How are they functioning? Now, regardless of what the treating physicians are saying, what is their function ability? Because remember, we're talking about a loss of wage earning capacity. We are not talking about compensating people for lost time. We're not talking about any of those other things. So the judge is supposed to think about what is the impact on this person's actual working ability. Now, this should be recorded in the medical records. There should be a measurement of their performance, their restrictions, the things that they were doing, what were the jobs they were able to do. Are they using the assisted device? Are they not using an assisted device now, like a cane or a walker or a brace? How are they working? What's their exertional ability? Do they have the ability to stand on their feet to do work? And remember, by the way, that we're compensating in terms of the pre-accident job, not any job. So does a desk worker need to have a very heavy exertional ability to do their work? And the answer is no, right? So we need to look into that. So that's the functional evaluation that we have to perform. And the last thing we have to look at is the person's education and training, whether they have skills that would transfer to other employment, age. And by the way, above the age 50 is considered advanced age in this jurisdiction. And then, of course, things like literacy and English proficiency is to be considered. We're not to consider whether the person has a legal basis to search for work in this jurisdiction. In other words, it is strange that they've attempted to say that someone can have a loss of wage earning capacity in a jurisdiction which, for example, because of their citizenship status or their work status, they actually have no work status in this jurisdiction. There is prevalence of thought that they would still be entitled to the loss of wage earning capacity award. I think that's wrong, and I think those cases should be tried. The vast majority of those matters are disposed of by way of Section 32. Those are lump sum dismissal cases. So again, the minimum compensation rate is 225 weeks. In our jurisdiction, we just showed you, or in our example, we just showed you that person would have been entitled to actually 250 weeks of compensation. So what does this mean, Greg? Can you show to me how this is actually calculated? So let's look at an example calculation. Let's imagine that our claimant had a 60% loss of wage earning capacity. And again, that's after taking into account their medical impairment, their functional ability, and their vocational abilities. The determination was a 60% loss of wage earning capacity. And their pre-accident average weekly wage was $892.34. Well, it's easy to calculate the rate at which compensation would be paid. It would be paid at 60% of their compensation rate, which would be their average weekly wage times 2/3 times 60%, or $356.94 per week. And it's easy to calculate how many weeks they would get compensation for. The answer to that is 350 weeks. So in this case, for our average weekly wage earner of $892.34 a week, they would be entitled to $356.94 a week times 350 weeks, which is roughly 7 years of benefits, or $124,929. Now, there's another interesting thing to be mindful of in this jurisdiction, which is that New York also recognizes an idea called total industrial disability or extreme hardship. In cases where the claimant has an overall disability exceeding 75%, the claimant may apply to the workers' comp court and say, look, my disability was very significant. I'm coming up close to my payments being all expiring. I think that you should find that I have a total disability based on my extreme hardship. And they can ask for this extreme hardship redetermination. They file a form called a C-35 with the Workers' Compensation Court. It provides mainly financial information to the court and explains how they can't pay for things in their daily life because of the debilitating injury they sustained, and why they have an extreme hardship. So be concerned about this. I want you to be aware of cases which are going to settle or adjudicate at a 75% or above disability level, because that claimant's going to have an opportunity to come forward in the future and try an extreme hardship case, or make an argument that they should be entitled to total disability. So be mindful about that when you're resolving matters. And for that reason, when I think a case is going to settle or resolve at those higher figures, I take steps to protect myself, or perhaps litigate that case to make sure it doesn't get to that level. All right, how do we calculate exposure in these cases, and how do we resolve them? So we're going to calculate exposure using the simple formula. The rate is going to be the average weekly wage times 2/3, subject to the loss of wage earning capacity determination, which is again made by the judge or agreed to between the parties. That's going to give rise to an award, which is going to be that rate that we just calculated times the durational cap. Now, there is a potential for us to take a credit for prior indemnity if that indemnity has exceeded the initial 130-week period and the claimant has reached MMI. And actually, this was written into the statute and has been effective since 2017. However, it's rarely possible for us to get that credit, because it's not just that 130 weeks, or that's roughly 2.5 years, have elapsed, but the claimant also has to have reached at maximum medical improvement. And therein lies the rub. Most treating physicians are not conceding maximum medical improvement, and that should be the trigger for you. In fact, I think it's best practice for you to put a flag in each one of your cases at the 130 weeks of temporary disability. Why isn't this claimant at maximum medical improvement, and shouldn't they be? Is it time for an independent medical examination to establish that they are, so that we can demand that we get this credit for indemnity already paid? So that's something to put in your system or flag in your files as a potential recovery. Now, once we've reached that point of MMI, both parties are going to get their own examining experts. Now, it's common for these experts to disagree significantly on the extent of impairment, okay? That's what they do. They shouldn't disagree on like what are the body parts established, because we should be telling them that. We should, you know, what is the injury type, that type of thing. But what's the extent of the impairment? And we're going to be hiring true independent medical experts. We can't communicate with them outside of the presence of claimant's counsel and the court. We can only send them medical records and a cover letter, which again is copied to all parties, has to be relatively neutral. Meanwhile, the claimant gets to go to their treating physician who they've built up a rapport with, and claimant's counsel probably has a long-standing referral relationship with. So we are at a disadvantage when it is a battle of the doctors. Also, the judges entertainingly will often say, well, if it comes down to an opinion of permanent residual disability, I'm more likely to weigh the opinion of the treating physician who treated them for a long period of time than your Dr. Greg who saw them for a one-time evaluation, which of course is ridiculous. It's like, I'm going to go with the person who they selected, they chose, and you know they have the relationship with, rather than this independent expert that is relatively impartial to the outcome of this overall case. But be mindful of that. You're going to, many of these cases devolve into a battle of the experts in general. Our experts are going to be very well qualified and pre-selected by us to be a little less paternalistic and much more objective, absolutely, than the treating physicians. How do we discount settlements? Well, we're going to discount settlements based on litigation risks. We're going to discount them on the value of right now money to the claimant. We're going to use, when it's appropriate, the present value discounting. The board itself publishes a present value discount that we are going to utilize, so that we make sure that when we're coming up with a suggestion on exposure in a case that's going to be paid out over 350, 400, 500 weeks, that we're discounting it to today's dollars, and we're making sure that we're giving our clients the best possible, clearest possible recommendation in terms of what exposure is going to be. And the next slide I'm going to talk about is internally what we do. First of all, I always want my attorneys, when they're working with you, to make a recommendation to you in terms of dollars rather than percentages. I don't like it when they make you try to figure out what we're asking you for. Instead of saying we think the matter has an amicable resolution of 50% of loss of wage earning capacity, I'd rather say we think it has an amicable resolution of 50% of loss of wage earning capacity, which equates to $89,250. You know, I want to be as clear as I possibly can. So generally speaking, you're going to hear us ask you for dollars, not percentages. We're going to make offers and counter offers. Opposing counsel makes demands, right? They don't make offers, they make demands. The other thing I think you should hear from defense is we should never be recommending you pay total. I mean, unless someone's lost a limb and there's a clear amputation or clearly total disability, right? I've got one case where a gentleman lost vision in both eyes as a result of the accident. Well, that's clearly a total disability case, and there's no way we're going to beat that. A suggestion that you pay total really is an abdication of what we're supposed to be doing. Those are cases that should be tried, even if you're just trying them to generate an opportunity to appeal based on legal error. What not to do, I tell my attorneys, do not be a calculator when we're talking about settlement exposures. That's not what we're here to do. I don't like that when they give you a big range, right? I don't like these big ranges. They're too big. A range where the client, or we tell you as a client, hey, the settlement could be anywhere from 25 to 75%. I mean, that's way too big. I mean, that's too big of a spread. That's a lawyer being lawyerly. They're trying to avoid responsibility, in my opinion, by making the range so huge that they feel like they can't be wrong if it turns out that it's on one end of that extreme or the other. If you see those things, please bring them to my attention, because I police that pretty strictly. We don't always assume that the client wants to settle, right? We know there are strategic reasons to not settling a case, right? So for example, there's a questionable injury or questionable accident that happens in our work location. Maybe we don't want to settle this case because maybe that would send a message to everyone else who works here. Hey, look, the company, when you do these things to them, you steal from them by faking an accident or having an unwitnessed loss or doing these things, they're just going to pay you money. So maybe we're incentivizing that, right? There are strategic reasons to not settle a case, and I want to keep those in mind, particularly for our clients who say, no, we don't want to settle this matter. And here's why, Greg. We have a principled reason. And then finally, I want us to be really clear about how we ask for settlement authority. It should be in dollars and not in terms of percentages. All right, let's talk some practical takeaways, and then I'm going to dive into your questions, and I hope there's a lot of great questions today. As we talked about, there is an LWEC determination process, and there are multiple steps that have to take place: medical impairments, then I'll look at functional ability, and then I'll look at vocational ability. So you've got some opportunity there to leverage your case for settlement. You can position your matter. You can create that leverage that you need to in your matter. So take that opportunity. As the litigation is progressing in a case, it's my opinion that the exposure of value of that case is going up and down. Hopefully, I'm doing things and we're doing things that are reducing the exposure, or at least helping mitigate the exposure. So we need to communicate that very clearly back and forth with our clients. We also need to identify the stakeholders. Ultimately, if the case is going to settle, who needs to be part of that decision as we assess and prepare the case for resolution? Let's know that early. All right. At this point, I'm going to jump over into answering questions, and I'm really hopeful that there are some good questions here for me to answer. So let me pop this open. I got some. All right, let's start at the beginning. I'm going to start with Lisa. Okay, Lisa gives me an unrelated question, and she asked this relatively early, it looks like, in the webinar starting. So it makes me think, okay, this one was on her heart. She wanted to ask me this question because Lisa asked Greg, unrelated topic question. We are seeing a lot of New Jersey resident claimants who are injured in New York and treating in New Jersey. We are finding out New Jersey medical bills are higher and understanding when we are trying to settle the case. How can we successfully argue so that this does not inflate the payout? All right, let me make my screen a little bigger here so I can see all these questions on one screen. Okay. Okay, great question, common question, right? What you're seeing a lot is New York workers' comp claimants, injured in New York, have a valid New York workers' comp claim, but may live in New Jersey, traveling to New Jersey to get their medical care there. Or more perniciously, we see a New York workers' comp claimant who lives in New York, treats in New York, had an accident in New York, but gets sent to New Jersey to the ambulatory surgery center or to the doctor's operating center to get their surgery in New Jersey. Why? Because New York has a medical fee schedule. New Jersey does not, right? So we've seen a lot of these cross-jurisdictional treatment issues. And then what does the claimant do? They bring a medical provider claim in New Jersey, or just simply make a demand that you reimburse them at what New Jersey has, which is called the usual and customary. All right, so I can help you, Lisa, with this question. First, it happens all the time. I have a large New Jersey practice. In fact, my next webinar is on New Jersey workers' compensation law. And we're defending hundreds of medical provider claims in that jurisdiction. However, in New York, or when you have a New York claimant who travels into New Jersey to get care, or a New York workers' comp case where the claimant lives in New Jersey, so they start getting care in New Jersey, you should still be paying the fee schedule and only the fee schedule. Then if the medical provider files a New Jersey medical provider claim against you, you should win every time on a jurisdictional basis. And in fact, I know you should win every time because we're the law firm that made the case law in New Jersey. The decision is called WATRIC. Then it came out in February of 2023 that analyzed exactly those facts. And in his opinion, Judge Leitner reached exactly that decision. So in our practice is that when we see a cross-jurisdictional medical provider claim, which sounds analog to what you're doing, we assert a defense in New Jersey. We refuse to pay it. We say, we'll pay you under the fee schedule, and that's all we're going to pay you. And then we file a motion to dismiss for lack of jurisdiction in New Jersey. We make the arguments, again, bolstered by the opinion I got in the WATRIC decision, and we win. So thank you for the first question. It is off topic, but it probably is happening to a lot of people. Again, I'm defending hundreds of them. There's probably thousands of them out there. and I'm very happy to help you with those problems. Suzanne, I asked the next question. Suzanne K says, Greg, what happens when the claimant doesn't attend multiple IME appointments? Okay, so this is a problem in New York. Typically, we will send them to an IME appointment. If they do not appear, my next thing I will do is I'll say, okay, I'm going to be a nice person and I will reschedule it for you once. But the second time, if they miss it, I file a request for further action in court saying you need to suspend all benefits or cancel benefits for failing to attend to my scheduled medical appointment. And there's a section of the statute, section 19, which says that the claimant must attend our medical appointments that we make for them. So I make the argument that they have now missed our medical appointment. They've missed it not once, Judge, but twice. And based on that, Judge should suspend benefits. And we are relatively successful in that. The judge should suspend their benefits until they attend your IME, which will generally motivate them to attend the IME. Now, the bigger problem is you're getting these no-show fees, $500, $800 for them not showing up to your IME. Unfortunately, we get stuck with those fees. The judges generally will not make the claimant reimburse us for those no-show fees, but that's our process. Okay, Miguel L says, Greg, for workers who may be undocumented, would one be able to use vocational factors and moreover the state's resources for retraining and job placement to potentially pursue a loss of a labor market attachment argument? Yeah, I mean, that's your argument. That's my argument to say, wait, you're saying this person has a loss of wage earning capacity because of their medical injury or their physical impairment. Well, I'm telling you they have a loss of wage earning capacity because they never had an earning capacity in this jurisdiction, period. Legally could never have been working. And that's the argument that we make. So yes, I would be pointing out that, Judge, things like states offered retraining or Workforce One or any of these other rehabilitation, what would be the point? Even if we did that, they still would have no legal working ability in this country. In practice, though, this becomes rather academic first because very few of my cases actually involve undocumented workers. That's simply because of the clients that I work with. But the second is when it does, usually it's a subcontractor of a subcontractor type of thing. We resolve those cases by way of Section 32. That undocumented worker certainly doesn't want to make their work status more apparent or their documentation status more apparent, okay? So Miguel asks the second question, would a claimant with lifetime benefits be able to seek a total industrial disability rating? They may not have an ending benefit, but some, depending on the date of injury, have a rather low compared to today's indemnity rates. So the answer is no. There is no cost of living adjustment, Miguel, for a total disability case. This is unlike Social Security or Medicare disability duration in that federal context where they do cost of living increases as the claimant ages. That never happens in New York. You are getting your benefit based on your date of loss and your average weekly earnings at that time. Lisa says, Greg, will you share the PowerPoint? Yes, this will be published on our website within a week. Iris says, what are some creative ways to combat migrating injuries and the board establishment of additional body parts? Well, Iris, great question, right? How do these cases start off with it? It starts off as a thumb injury, and somehow 2 years later, it's the whole hand, it's the right shoulder, it's a PTSD claim. Oh, I got a concussion that I didn't tell anybody about, and my left ankle is aching, right? Like, how do these things keep migrating? How do they keep getting worse? So there's really, unfortunately, it's not going to sound too creative, but I just want to talk about belt and suspenders stuff. The first thing is, let's continue to go back to two things. First, the employee claim form, right? That C3 that is filed at the beginning of the case, employee claim form, has to be signed by the employee. And they have to say, here's how I got injured, and here's the body parts that were injured in this accident. And they also have to certify if they've injured them before in any other accident, okay? So that's an incredibly important piece of signed documentation in every workers' comp case that should help us curtail the gradual addition of additional body parts or the migrating injuries. Now, claimants' counsels resist having their clients file them. And technically, you can have an active and ongoing workers' comp case in the state of New York and never file an employee claim form, right? But in every case that we defend, the first thing we do is say, is there an employee claim form? Is it signed? And if not, I want one, right? It's the first thing we ask opposing counsel for. So that's the first thing. The second thing is, let's go back to those foundational early medicals. What was the mechanism of injury? What did they complain of in the emergency room and the first time they saw the orthopedic? And can we use that to sort of constrain them adding in additional body parts later? The third thing I'm going to say is we need to be vigilant. As new body parts come in, we need to challenge them. And this might be an opportunity for us to get an independent medical examination in order to challenge the new body parts. I know it sounds crazy, like, Greg, you're going to go spend $2,000, $2,500, $3,000 on an IME to keep out additional physical therapy that might only cost $2,000 for an unrelated body part. I'm like, yes, because you don't want to end up getting stuck paying permanency on all those body parts. So get early in IME. Fourth thing I would do, particularly when they start bringing in new body parts, now you've got the sensation that they're starting to stretch their claim out, right? They're starting to bring more things into it. They're starting to play around. I'm thinking surveillance, covert surveillance. I'm thinking, let's get into the social media history. Let's see what else is going on with this person. It's one of those big red flag triggers that's getting me to really investigate and get invested in this case, because I can see what they're doing. They're trying to do things to puff this case up and make it more, valuable to them in terms of total recovery. Okay. Fifth thing that I would say too is there's certain treaters out there that we know are going to add in more body parts and do unnecessary treatment. Who are they? Well, they're all being sued right now. And a couple months ago, I talked to you guys about the tradesman decision. So when you see Surgicore, Surgicare, any of those medical providers, when you see Andrew Marola, when you see the New York Spine Institute, we see any of these physicians that are now being pulled into this giant racketeering and lawsuit that's going on about over-treating claimants on purpose and identifying workers' compensation claimants as an opportunity for them to over-treat. We see any of those names of those treaters, that should be sparking red flags too. So making sure that we're being very careful about the treatment that we are paying for and what we're authorizing. And the last thing I would say is being vigilant about challenging any variance requests that come in on your cases. Remember, when the doctor wants to start treating a new body part that isn't already established in your case, they have to file that variance request or that request for prior approval. You should be vigilant about those. You might seem innocuous, it might seem minor. Oh, they're just looking for some, they've been in a year of treatment for their hand and now they just want some physical therapy so their back aches. Be very thoughtful about that because you might be establishing a new body part by doing that. So those are some of my ideas or some of the things that we would do in a case where we can see that it's going in a direction where they're going to bring more stuff into it. So great, guys. This is a great amount of questions. I love these questions. Thank you for everyone who asked me a question. It looks like I got through them all, but if I didn't get your question, please email me. I'm always happy to review them. If you're part of this webinar and you come regularly, you know that I always talk about our newsletter. Please subscribe to that on our website. You know that we publish multiple podcasts every month. My favorite podcast is my partner's podcast, Christians, which is released every third Friday. This third Friday, he'll have a new topic. And join in for all the other opportunities we have for learning at this firm. I hope everybody else has a great rest of the summer. Next time I'll see you will be beginning of August. Between now and then, enjoy your vacation, and I'll see you guys next month.